Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. In one of my last videos, I talked about how jury instructions can be a frequent source of reversal for criminal convictions. And there are a number of reasons for that, one of which is you give the jury simply a roving commission that if anything sort of trips their trigger and makes them think a person is guilty, they're guilty. And of course, that's a gross oversimplification of what a roving commission is, but basically, it allows the jury to speculate about what might be or what might not be. So anytime you have a jury instruction that encourages speculation, it's a bit of a problem. There are also situations where the law is misstated in an instruction, and when the law is misstated in an instruction, that can also result in a reversal. Now, yesterday in the Crumbly trial, the thing that I commented on was the fact that reasonable doubt does depend on a lack of evidence, and the jury was asking specifically about that, and the judge did not refer them to that instruction, which I believe might very well be trial court error and reversible error on appeal if there is a conviction that ultimately comes out of that. As it stands now, they're 8 hours into the deliberations. They still haven't reached a verdict, so I think they are certainly doing their constitutional job of taking this slowly and seriously and studying the evidence. So I wanted to give you a good example of something that came in through my inbox today. I have Google Alerts, and one of the Google Alerts I have is for convictions that are reversed, and this is one that came out of Minnesota, and the reason for the reversal is a jury instruction. So let's take a look at that now. This is the state of Minnesota versus Elsa Sigura. Now, this is a terrible case. Just all of the facts in it are awful. Elsa Sigura was friends with was actually the boyfriend of a drug dealer by the name of Wiggins. And Wiggins was upset with the boyfriend of a realtor. Wiggins' plan on getting back at the boyfriend of the realtor was to go get the realtor, kidnap her, murder her, and then also murder this person that had ticked him off. So that's essentially what Mr. Wiggins did. He hired two of his associates who, interestingly enough, one of them had the last name of Barry and the other one had the first name of Barry, which would make it rather difficult for me to talk about the facts of the case because I'd get the Barrys confused. But at any rate, Elsa, her sole act in this conspiracy was to convince the realtor to meet her to show her a house. So the realtor went to this house to show the house, and instead of Elsa showing up, the boyfriend's hitmen showed up. Wiggins's hitmen showed up and kidnapped her. They later killed her. They badly wounded the person that they were after, the boyfriend. And of course, as all of these conspiracies go, the idiots were caught and they were convicted. And Elsa was charged as an aider and an abettor. So let's look at just sort of the gestalt of all of this. Like a lot of appellate courts, the Minnesota Supreme Court here, they don't bury the lead. It says, although the state presented sufficient circumstantial evidence to sustain defendant's convictions for both first-degree felony murder while committing a kidnapping and kidnapping to commit great bodily harm or terrorize under an aiding and abetting theory, it failed to present sufficient evidence to sustain defendant's convictions for first-degree premeditated murder and attempted first-degree premeditated murder under an aiding and abetting theory of criminal liability. Defendant is not entitled to a new trial on her unobjected to claim of prosecutorial misconduct. Now, here's interesting. The district court did not abuse its discretion by denying defendant's proposed jury instructions. The district court abused its discretion by giving erroneous jury instructions on accomplice liability, and the error was not harmless because it cannot be said beyond a reasonable doubt that the error had no significant impact on the verdict. And they overruled another evidentiary point. So let's look at the part of the opinion that deals specifically with the instructions. So in part 3 of the opinion, they talk about Sigura's argument that she's entitled to a new trial due to erroneous jury instructions. And she raises several issues, including the district court abused its discretion by denying her proposed accomplice liability instructions, and the instructions it issued were confusing and misleading. So they state the standard here. District courts are given wide latitude for selecting language for jury instruction, but an instruction that misstates the law is error. We conclude the district court did not abuse its discretion by denying Sigura's proposed instructions. We agree with her that the district court's instructions materially misstated the law. Because we are not convinced that this error was harmless, Sigura is entitled to a new trial. We therefore reverse Sigura's remaining convictions and remand for further proceedings consistent with this opinion. So she contends the court committed reversible error by denying her accomplice liability instructions. And basically what the Supreme Court had a case several years ago called Rosemond versus the United States, and it was an accomplice liability case. And basically they said the intent requirement is satisfied when a person actively participates in the elements of the charged offense. Intent must go to the specific and entire crime charged. Well, here the Minnesota Supreme Court engages in a bit of sophistry. First of all, it claims that it's not binding precedent because it involves the interpretation of a federal statute. But that's not really the case. The issue that the Supreme Court was deciding when they were deciding this issue of accomplice liability was really not statutory interpretation. It was basic fairness, fundamental due process. So the Supreme Court concluded the jury's instruction was erroneous because it permitted a finding of guilt based on the defendant's knowledge of the presence of a firearm after his participation in the underlying traffic offense. And so Sigura's proposed language relates to the intent requirement. We've previously stated that jury instructions must explain the intentionally aiding element, and that requires the jury must find beyond a reasonable doubt that the defendant knew his alleged accomplice was going to commit a crime and the defendant intended his presence or actions to further the commission of that crime. Nevertheless, the court gets wide latitude. The state's assertion that we've already rejected a Rosemond-like instruction is inaccurate because they have basically affirmed an instruction that way. Nevertheless, we have never required that accomplice liability instructions explain the intentionally aiding element go to the specific and entire crime, as Sigura argues. Therefore, we conclude the court didn't abuse its discretion. But it did commit reversible error by giving a hybrid instruction that incorporated both principal and accomplice liability concepts. Specifically, she points to the district court's use of the language the defendant or another or others when describing the elements of the underlying crimes that Sigura allegedly aided and abetted. Sigura claims the addition of this language makes the jury instructions hybrid instructions, and this language was confusing and misleading. And the court says the district court abuses its discretion if the challenged instruction confuses, misleads, or materially misstates the law. And we determine whether they are fairly and adequately explain the law. However, a mistaken jury instruction does not require a new trial if the error was harmless. An erroneous jury instruction is harmless only if it can be said that beyond a reasonable doubt, the error had no significant impact on the verdict rendered. Hybrid instructions are instructions that combine accomplice liability and the underlying elements. The danger of such instructions is that when the district court conflates the elements of accomplice liability and the underlying substantive offense, the instruction risks omitting the intentionally aiding element of accomplice liability. This is sort of what I talked about in terms of a roving commission. By virtue of putting in the elements of principal liability along with accomplice liability, they essentially give the jury the ability to roam freely through the evidence and pick a theory upon which to find the defendant guilty. And that is not supposed to happen. So in this particular instance, they found that the district court must separately instruct the jury on accomplice liability and on the underlying elements of the substantive offenses. We agree with her contention. Based strictly on form, the district court's instructions comported with case law. Consistent with our rule in Ezekiel, the district court separately instructed the jury on the underlying elements. Moreover, the district court gave a separate accomplice liability instruction after instructing the jury on the elements of each substantive offense as recommended by the criminal jury instructions. However, the practical effect of the district court's addition of the language "the defendant or another" was to combine accomplice liability and the underlying elements. And that's the concern that led us to put an end to hybrid instructions. Not only does this additional language materially misstate the law, but it also made the instructions confusing and misleading. And so, as a result, they reversed the conviction. So if you go down here to the end of the opinion, and here is the important part of the conclusion of the opinion. We reach our decisions in this difficult case with full recognition of the grievous loss suffered by Bao's family and the communities involved with this case, as well as the injuries inflicted on JMM. Now, Bao was the realtor who died. JMM was her boyfriend. He was the one that Wiggins was upset with. We realize that our opinion may result in another trial involving these difficult facts and intensify the grief of those affected by the senseless acts of violence perpetrated on Bao and her boyfriend. Nevertheless, we are duty-bound to ensure the defendant in a criminal trial is not convicted based on insufficient evidence or erroneous jury instructions that were not harmless beyond a reasonable doubt. On this record, we conclude that these standards were not met. For the foregoing reasons, we reverse Sigura's convictions and remand for further proceedings on the kidnapping and felony murder charges consistent with this opinion. So essentially, they have reversed the first-degree premeditated murder convictions. The only thing they can charge her with now and proceed to trial on are the kidnapping and felony murder charges. But of course, they're going to have trouble with the kidnapping because she didn't actually do the kidnapping. They have to proceed under an accomplice liability theory, and because they're not going to have the whole body of evidence in here in terms of everything that happened, because a lot of it is not going to apply to that, well, then the only thing they have is kidnapping and felony murder. And of course, the predicate felony for felony murder here is the kidnapping. What the state is likely to do, since they have the other people pretty well wrapped up in this case in terms of going to jail, they will probably come in and offer her an opportunity to plead to kidnapping and take a term of years. Maybe if she's already served some time, 2 or 3 years, they might give her another 2 or 3 and let her go. In that way, they will reduce the impact on the victims, and they'll also still get a little bit of justice out of this. Now, keep in mind, I don't think there's any way you could conclude that she was blameless in all of this, even though she claims that, she had no idea that they were going to kill these people. And that may be true. But when you set in motion a conspiracy, even if you are not fully informed of the acts that are going to go into the conspiracy, you are still responsible for everything that happens. So in terms of it being a fair ruling, I think it's a fair ruling. The dissent has a different view on it. The dissent says the concurrence says that they hold, with one exception, I disagree with the court's holding there is sufficient evidence to sustain convictions for aiding and abetting kidnapping and first-degree felony murder. So this judge would simply throw everything out and let her go free. Fortunately, that was not the way that this worked out. So that's what I have for you today. It's just an interesting little case involving jury instructions, and since it came up in Crumbly, I thought this would be a good teaching tool. If you have any questions, leave them in the comments down below. Like, share, subscribe, all those things we ask you to do. And of course, if you have the opportunity today, please take a moment and do something nice for someone. You never can tell what kind of day somebody else is having, and sometimes just reaching out and making a connection, smiling at them, opening a door, calling them a friend, sometimes that makes a big difference in someone's life. As the habitual line crosser sometimes reminds us, there are people out there fighting battles we know nothing about. And sometimes it's nice to be able to help them in that regard. All right, that's what I have for you today. Thank you so much. Catch me down here at the beach again next time. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.